Hi, I'm Caitlin Embrich. I'm an associate attorney here at Sherer Law Offices. We have offices in both Belleville, Illinois and Edwardsville, Illinois. The topic of conversation today is the new tax code and how it affects your maintenance payments. Under the current law, maintenance is tax deductible for the payor and taxable income for purposes of the recipient. And what that means is that when we are figuring maintenance payments, we understand that that's going to be considered taxable income for the person receiving that, and they add that as income on their tax returns each year. That's all going to change with the new tax code. It's not going to change if you already have a divorce decree that awards you maintenance. Those people are going to be grandfathered and allowed to continue to deduct their maintenance payments and tax income on the recipient. However, any new divorce decree and new award of maintenance that's entered after January 1st of 2019, that's all going to change. What's going to happen is that maintenance will no longer be tax deductible for a payor and will no longer be taxable income for the recipient. What does that mean? It means if you may be paying maintenance and you think you're in the middle of a divorce and you think you're going to have a maintenance obligation, you probably need to get that finalized before the end of the year in 2018. It also means that if you are going to be receiving maintenance, you need to be thinking about how that's going to impact your taxable income and what that's going to do for tax purposes. We can answer all of those questions for you here at Sherer Law. You can visit us online at shererlaw.com.